The things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Welcome to the show, everybody. Thanks for joining us today. Our topic is top strategies to clear title through probate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. You can find us on YouTube, you can find us on Facebook, and you can find us on Twitter, or now known as X. And you can find us at the handle at InRem Podcast. That is at InRem Podcast. With that, I'm going to turn it over to Sean, who has our legal update.
Thank you, Andy. So our legal update today is jumping back into our What If series. So we took a short break the last couple of weeks to go over some recent legislation out of Alabama, which I think kind of shows us the trend of legislation involving real estate investment activity and 40-year listing agreements and things like that. But we're going to jump back in, do another what if segment today. So it's what if a seller on an agreement for sale files for bankruptcy. So, and an agreement for sale, also known as a contract for deed, a bond for deed, a land installment contract, depending on what state you're in, is basically what we call an executory contract, which means that the purchaser does not receive fee simple title to the property. There's no deed that is put in the purchaser's name from the beginning. Instead, the purchaser is given an equitable interest, possessory interest, the right to make improvements and repairs to the property, and to basically treat the property as their own so long as they make payments to the seller pursuant to whatever the terms of the agreement for sale states. And then when they fully performed their monetary obligations and made all payments, at that point, the seller then provides a warranty deed to the property to the purchaser. So what if in the meantime, if from the date of the agreement for sale to the date that the warranty deed is transferred at some point during that period, the seller goes and they file for bankruptcy? What happens? Well, in that case, the trustee has a decision to make. So basically it becomes the trustee's decision. The trustee looks at this and says, okay, it's an executory contract. So what does that mean to me? What does that mean to assets of the bankruptcy estate? And the trustee believes that there's assets or that has sufficient equity to be a substantial asset to the bankruptcy estate, the trustee can basically unwind that contract. Now, that doesn't mean that the purchaser is left, out there having paid all this money and holding, towards the purchase of the property, holding the bag. Instead, the trustee would basically unwind the transaction. The amounts that the purchaser has previously paid would have to be paid back. There would probably be other compensation to the purchaser, such as, moving costs, expenses, the expenses associated with if they paid any, previous commissions for the property, closing costs, moving expenses, those types of things, relocation expenses. All of that would be things that would have to be taken into consideration by the trustee in determining if it makes sense to unwind it. But the contract is subject to being unwound. Now, if the trustee decides, no, it's not worth it, we'll just let the contract stand, then in that case, the purchaser can continue to make payments on the agreement for sale. Those payments become an asset of the bankruptcy estate. The agreement for sale becomes an asset of the bankruptcy estate, and nothing changes. But it really falls upon the trustee to make a decision whether to unwind everything and put the parties back in the status quo, or if it makes sense just to keep the agreement in place and have it be an asset of the bankruptcy estate.
All right. Thank you, Sean, for the legal update. With that, let's talk about a few announcements and a few reminders for you, the listener, at Hear the In-Rem podcast. So tomorrow at 5:00 p.m., we have our Creative Finance Collective. What is the collective? It is a collection. It's a membership of attorneys that have their hands in creative finance, whether it be here in the state of Arizona or from states all over the country. In fact, most of the folks that have joined us from week to week in the Creative Finance Collective are lawyers from different states. So they bring to the table an approach from different jurisdictions where laws apply differently. It's really kind of a great opportunity for us as lawyers to learn about what other lawyers are doing in creative finance in other jurisdictions, and how they're approaching that. But not only that, we get to see what lawyers are, the conversations that they're having with clients and other investors from all over the country. And, there's a lot of different strategies and approaches that investors are taking when it comes to creative finance. So it's been a remarkable opportunity. And it's also a nice opportunity for you, the listener, because we take questions the entire hour. For an entire hour, we are captive to you. So if you have questions about Subto transactions, creative finance transactions, what that looks like, maybe you're having trouble getting a meeting with an attorney, this is an opportunity to brainstorm with attorneys that are in the space to get an idea, maybe whether you're on the right track and where you need to be. So make sure to join us tomorrow. That's 5:00 Arizona time. Adjust your time schedule if you're from somewhere else in the country, but 5:00 Arizona time, we will be live and taking questions throughout the entire time. Also, for today's show, we are taking questions from you, the listener. Today, we're obviously talking about probate and title issues that you, as an investor, typically might run into if you do this on a grand scale, and where you might find yourself in probate and what that looks like. So if you have questions, we're taking questions today, and I'm going to turn it over to Maya, who can give you direction on how to go ahead and state those questions so we can give you an answer.
Thank you, Andy. Happy Tuesday, everybody. It is the 8th of August, and you are watching the In-Rem podcast live. Thank you for watching. If you've joined us on the show before, you know what this is. Andy, Sean, and our guests do take questions live on the show. Wherever you're watching In-Rem, whether it's from Facebook or YouTube, we are monitoring the chats for your questions, and we take the last 10 to 15 minutes of the show to answer them. We do take questions in order of priority, so don't wait. If you have a great question in mind related to today's topic, make sure to leave it in the comments, and we'll try to get to all the questions at the end of the show. So that's enough from me. So let's get into clearing title through probate.
All right. Thank you, Maya. With that, we're going to get right into the topic and our discussion. We're talking about title issues created and that involve the probate court. So when you find yourself in probate, how do you get out of it? How can you move through those title issues? And with us today to talk about that is Arizona attorney Dustin Schanaker. Dustin, thanks so much for joining us.
Of course. Thanks for having me back.
Yeah, we appreciate you being with us. So I know you've been with us before, but we've got a lot of listeners that may have not seen you, met you, heard about you. So tell us a little bit about you, your practice, and how you got involved in doing what you're doing.
Sure. So I work here at Fowler St. Clair and been here going on 10 years now.
It's been a little bit.
It has, yeah. And so yeah, when I first kind of joined, it was just I got thrown into the fire, and probate naturally became one of the things that, I don't know if you guys just didn't want to do it or what, but it kind of fell in my lap. And I enjoyed it, kind of that planning process on the estate planning side. And then,
yeah, I was going to say, you always wanted to be an estate planning
Right.
lawyer, right?
Right. And so probate is kind of that natural outflow of the other side, right? We have people who maybe haven't planned or haven't planned well, and now we're trying to pick up those pieces to fix the problem. And so they kind of go hand in hand to me, and I enjoy that aspect of it.
So jumping into probate, let's kind of start at 30,000 feet and assume the listener, everybody has some sort of concept or understanding of what they think probate is. Usually their idea of what it is, unless they've been through it's pretty far off as to what it actually is. But why don't you describe for the listener what is probate and what is it generally designed to do?
Sure. So every state's going to be different, but for the most part, there's some general principles. When somebody passes away, something has to happen in order for their assets, whether it's real estate or bank accounts, investment accounts, something has to happen in order for those assets to be distributed to the right people. And generally, that process is called probate. There's certain assets that avoid that altogether. That's where the trusts and payable on death type things come into play. But for anything else, it has to go through this probate process. And so in Arizona, it's the process of we have to go to the court and we have to explain to them all the information they need to know, whether there's a will or there's not a will, who's going to be the person that is seeking the authority to now deal with these assets. How are they related? Who are the heirs? If there's a will, we've got to identify all the people named in the will that are going to be receiving assets. When there's no will, we identify under Arizona law who those heirs are. And so the court then, there's different types, and we'll, I think, get into that in a little bit. But at some point, the court will then grant authority to somebody to be able to act on behalf of the estate. And that person in Arizona, we call it the personal representative. Other states call them the executor, the administrator, anything like that.
It's interesting. I think the public's general perception of probate is that it's a place to handle family fights, which of course that could be what it means, but that's at its most basic level, given what you just said, that's not really what it means at all.
No, it plays out that way sometimes, but generally it's simple, right? It's going to the court and just asking for that authority to be able to distribute the assets to the family members, usually. And it sometimes it doesn't involve fights. Sometimes it does.
Which makes sense because at the end of the day, while we cease living, our assets don't stop, right? They continue. That real estate that we own is still there.
Mm-hmm.
The vehicle that we owned is still there. And our name's still sitting on that title. So it's really solving this legal quandary. How does Andy Fowler, who's on this title, who's no longer with us, execute it and deliver it to somebody else?
Right.
So it's really meant to fix that legal issue that's created upon our death. So talk to us about, I know this could theoretically change from state to state. We're in Arizona, you're an Arizona attorney. What courts within Arizona anyway does probate play out?
Sure. So it's in the Superior Court. It's got usually, at least in Maricopa County, there's a whole probate, group of judges that usually commissioners. But there's probate judges, and so it gets filed in the Superior Court. And depending on whether it's a formal or an informal probate, you're going to have a judge assigned, and it's a judge. If it's an informal probate, then it's going to be more or less handled without a judge's involvement, because it's the more simple type of setting where, as long as you can check the boxes, the probate registrar is the one who will then grant that authority and sign off saying, yes, you have the authority to now act as that person who is deceased to deal with their assets.
Dustin, I have a question for you, and I've learned this from you over time. We always think, oh, well, probate is just dealing with, like disputes among the heirs, administering the estate, appointing somebody to handle the estate. But one of the things I think people don't realize, and you've explained this to times, is more than that. Meaning, if there's any dispute regarding assets involves, quiet title or, a release of a lien or even a business dispute, those can be handled in the probate court, correct?
Sure. Because we're in Superior Court, the commissioner has the authority to deal with any other related civil matters. And so maybe you get appointed as the personal representative, but there is some lien that needs to be cleared up. That can be done in the probate court. And the commissioner has the full authority, like any other civil judge, to be able to quiet title or do any of those other things.
And what does that look like? I mean, if I'm in the probate court, I'm a personal representative, and there's some problem, somebody has falsely recorded a document against a piece of real property that I'm supposed to administer. And I'm like, well, I don't want to go file a separate lawsuit. I mean, I'm in probate court. Like you said, I'm in superior court with a judge who has, potentially authority to deal with this. What would it look like if, some third party wrongfully recorded something against the real property that belongs to the estate, and I'm a personal representative, I need to resolve that? What would be the steps that a PR would go about, dragging that person into the probate proceeding to figure this all out?
Sure. So the general rule is that the rules of civil procedure control unless they're changed by the rules of probate procedure. And so the slight difference that we have there is we've already got a current probate action opened, and the personal representative can go file a petition to quiet title on that property. And so your general civil rules are going to control. You file the petition, you still got to serve that person if it's a third party, and then probate court handles it from there. They'll set a hearing on it and give that third party an opportunity to respond. But ultimately, if the judge finds that the relief we're seeking is there, then they'll issue an order that grants that.
Yeah, you can be dragged into probate court unexpectedly. I think of a story I had. I was and have served as a trustee on trustee sales for real estate over the years. And in one such case, I was acting as the trustee on a trustee sale, and the owner of the property was deceased, but a PR had been appointed. I thought this was the wrong venue for this, but they went into probate court where they had been and got the court to stop the trustee sale. It hadn't commenced yet, but to basically they put a temporary restraining order in place and then called me in to testify as the trustee in the sale. So we ultimately prevailed, but that was an example of the being brought into the probate courts, and the probate courts having the power to basically issue temporary restraining orders and halt everything. So yeah, they really do have the power that that one could be that one might expect from the general superior court, right? And I guess the main question about whether you might or whether they might have jurisdiction is whether they're dealing with a deceased assets, or a deceased. What other type of so we mentioned before disputes among the family, and maybe that's an obvious one, but is that an area that as well that the probate courts resolve?
Sure. That's usually going to be in the formal probate context, where maybe you have siblings that are fighting over who should be the one to get appointed as the personal representative. We can't agree. It usually happens when there's not a will, because if there's a will, it's going to mom and dad maybe said, we want this child to be the one in charge. But even then they can still dispute that. But that's usually what the context is we're fighting over who has authority, or we're going to fight over who should be getting the assets. Mom promised me this one. Well, okay, did mom put that in writing? Not, sorry, you're out of luck. But those are kind of the two big things that lead us into those family dispute scenarios where there's a formal probate. And in that case, it's essentially litigation. If one party is saying I should be the personal representative and the other sibling maybe or other family member is objecting to that, we're in litigation. There's going to be discovery. There's going to be motion practice to try to prove why this person should be in charge and this person shouldn't be in charge. And so you can kind of expect normal litigation at that point.
So let's talk about some common title issues that an everyday investor might see pop up when buying real estate, and kind of work through them and talk about, what needs to be done or what those are. But let's start with a common one everybody sees, and an easy hypothetical. I, as an investor, enter into a purchase contract with a seller, and the seller dies before we close. What's the title issue, and what do you got to do in probate to work through that?
Sure. The commitment for title is going to say that they need certified copies of the letters of appointment showing that somebody has the authority to act on behalf of that now deceased seller. And so that's what we need. We need that golden ticket of the letters of appointment. And so to get that, you as the buyer, the investor, is going to have to find the right person. You're going to have to find the heirs. And so that means maybe doing an heir search. That means tracking down somebody who is hopefully the right person, but finding somebody who can then go to the court and ask for that authority. And they will then, if the court agrees, they'll appoint that person as the personal representative, and they will issue the letters of appointment. And so now that that person has that document from the court, give that to the title company, and now they can close on behalf of the estate of the person who died. So the contract is still enforceable, right? Because it was with the owner, and then they died. And so that one's much easier because we have an enforceable contract with the estate.
I'm not sure that this would qualify as a title issue, but I think this is an investor mistake that could be commonly made. What about investor hears that or finds through the public records, maybe a obituary in the paper that so-and-so has passed away, makes some cold calls to the property to see if they can lock up this property, knowing that the estate's maybe going to think to sell it. They get in contact with, Aunt Jenny or whoever it might be, and they're like, I'll buy it. And they say, great, we'll sign the agreement and everything else, without checking whether there's a probate or anything else. Is that contract even enforceable?
Sure. I'd say that's probably the number one mistake that I see and problem when I'm dealing with these investors who are scouring the probate, looking through the obituaries and finding these kind of pre-probate cases.
Because of course they're trying to do this quick and get ahead of
Right,
everybody else,
right.
all the other investors.
And it's a problem of authority. And so if Aunt Jenny is the one that you're in contact with, that's great. Maybe she is the one who will eventually be the one receiving the property or getting herself appointed as a personal representative. But the problem is that right now, until that probate process has been started and they have been appointed by the court, Aunt Jenny has no authority to act on behalf of the estate. She could sign any agreement, but it's not enforceable. In order for it to be enforceable, you either have to be the deceased person, which obviously they can't sign a contract, or you have the authority from the court to act on behalf of that person. And then the other kind of related problem is maybe Aunt Jenny's not the right person. Maybe there's a child of the person that died who takes that priority above the sibling of the person who died. And so kind of under any of those circumstances, you run into problems of, sure, you got them to agree to a price and that they would sell it to you, but they don't actually have authority. So even once they do get appointed as personal representative, they can turn around and go sell that to somebody else. Or they're not the right person, and the person who does get appointed as personal representative doesn't want to sell to that investor.
Well, what if the investor's clever and he says, aha, Dustin, I know you're going to say that, and I found out she had a power of attorney. Does that work?
I wish it did.
Why does that not work?
No, powers of attorney cease upon the death of the principal. And so it gives gives your agent the power to act on your behalf while you're alive, either when you're incapacitated or just immediately, but it doesn't give that power. It doesn't extend past the death. As soon as you're deceased, your power of attorney document is no longer valid and the agent can't act on your behalf.
So after the death of the property owner, are you saying then that the personal representative, once appointed, do they have any limitations in their right to contract on behalf of the deceased, or are they the deceased for all intents and purposes?
If they're appointed as the personal representative with all of the full powers, duties, obligations of the personal representative, yes, they have the ability to do anything on behalf of the estate, subject to certain duties. They have the duty to act in good faith, to maximize the value of the estate, to act prudently. They can't self-deal, so they can't go sell the property to themselves for $5 to the detriment of the heirs. They have to go follow those duties and maximize the value. And so we kind of run into some problems there potentially with investors who are trying to get it on the cheap, right? So that they can make a deal. Well, the question is, does that personal representative have the duty to go sell this on the open market to be able to get more money for the other heirs? It's potentially a problem. And so we have to find kind of how to balance that. Maybe this deal is better, not because the price is better, but because of other factors of a pending foreclosure. That's a common one where we can say, well, we might not be paying as much as the investor might not be offering as much. But we've got a time crunch. There's an urgency here. And so for that reason, this is the best deal because we can get something from it before it forecloses. But yeah, the personal representative does have free reign subject to those duties that they have.
Dustin, what would an heir do if they don't like the transaction the personal representative is about to enter into or is entering into? Maybe it could be twofold, right? Maybe it's like, hey, like you said, I think we can get a better deal somewhere else. Or B, I already have some arrangement in place with some investor or buyer or somebody, or my, friend or somebody that wants to buy it, and I want to sell it to them. I don't want the PR, selling it this way. What can the heir, if anything, do to basically hold the PR's feet to the fire and make sure that they, sell it through the proper, course and channels?
Heirs can always, interested parties, anybody that's related to this probate can always seek injunctive relief. So if the personal representative is going to be selling it either for maybe a smaller value than what they think that it's worth, or they think that there's self-dealing involved, or for whatever reason, there's reason to seek this, they can seek injunctive relief from the court, from the probate court, and say, hey, we've got this problem. Stop the sale, prohibit the personal representative from acting while we sort this out. And so maybe then the heir would say, well, we want to get more for this. So they can actually petition the court as well it's kind of like an auction. They'll hold a hearing to approve the sale of the real estate, but you publish notice of that and give other investors, other buyers the opportunity to appear at that hearing and just outbid each other. And it's just a bidding war. It gets the most money for the estate and the heirs. So that is an option as well.
So basically, if push comes to shove and the personal representative is required to go into court, ask the court to approve the sale, that gets published. And if, let's just say I'm an investor, where would I go? Like the Business Journal or the Business Gazette, or, where am I going to find these notices that I can then show up and be like, hey, what's the deal on the table, and, try to match it or whatever?
Sure. Scour the internet, scour the old newspaper. I don't know who does that anymore, but the requirements under the probate court and the probate rules are that you publish in a newspaper of general circulation in that county. So we use, I think, the Arizona Capital Times, and it just gets published in their notice section, and it's, tiny print, but it's in there. And if you look through there, you can find all kinds of notices of hearings, of death, of notice to creditors, all of that.
So if you were an investor, and this is just, I guess, for general purposes, because there's a lot of notices that go in there. If you're an investor and you're looking for opportunities to be involved in, bidding at bankruptcy sales, probate sales, and just other general things that you want notice of regarding business and lawsuits and things like that, I mean, you really should be on a regular basis finding these sources where attorneys and parties are publishing these notices and keeping an eye out, because I mean, I don't know many investors that are doing that.
Sure.
But it seems to me that if you have the ability to go in and, compete for a property, whether it be in probate court, bankruptcy court, or, at the courthouse steps, man, you should, right?
Right. I think investors maybe think, oh, the recorder's website, right? That's the place. But this type of notice doesn't get recorded; it just gets published.
Yeah.
And so, yeah, looking through the actual newspapers or their websites can turn up some of that as well.
Dustin, talking more about the personal representative's power to act on behalf of the deceased. So we talk a lot about creative finance on this show, buying properties subject to. We've got an entire creative finance collective to talk about creative financing. The question here is, could an investor who's really made that part of their investment strategy buy a property from an estate subject to the existing loans on the estate? So hypothetically, grandma who passed away had a loan, a 30-year fixed mortgage at 3%. And maybe the market's gone down a little bit and they couldn't sell it for what they could sell it a year ago, but there's an investor saying, hey, I'll buy this subject to the liens, and I'll even throw in a kicker. I'll give you over fair market value just so I can get that loan. Does a PR have the authority to enter into a transaction like that and play that out? What would they need to do, assuming they could, to make a transaction like that happen?
Sure, they have full authority to enter contracts, they can even lien properties. And so they have basically the full authority that the deceased person would have had. Again, subject to those duties that we talked about earlier. And also kind of keeping in mind the time frame, right? Probates generally on the short end go 6 to 8 months. But they have a 2-year mark where at that point, if it hasn't closed by 2 years, then the court's going to at least get in touch with you and say, why isn't this closed? But so depending on the timing of what that agreement looks like, sure, they have the full authority to do it, as long as they can show that it's for the benefit of the estate.
Yeah, what do you think showing that it's for the benefit of the state is the biggest hurdle? Because I would imagine the heirs typically want money and want to run and move on.
Right. So that's where it's kind of the timing thing of it is you have to balance the added value that the investor is offering versus that now delayed time for the heirs. A lot of times you have these cases where the personal representative is the sole heir, right? They can do whatever they want. And so in those cases, it's easy. You might run into problems where there's 6 siblings that are going to be receiving the estate, and that's where maybe you've got some problems of they want their money and they want it now.
Dustin, let me chime in here, and
Sure.
I get what you're saying about them wanting, their money right away. But I want to talk to you about 2 things. So the first is, on say a seller financing or a subject to transaction, where the estate maybe will be carrying back a note. A lot of people, I think, and even PRs, and maybe even some attorneys that do probate don't fully, I think, appreciate the fact that in that case, all you're doing is really swapping assets, right? So instead of distributing the real estate's being sold to a third party. And in reality, you're getting back for the estate a promissory note, which, as we know, and the big banks do it all day long. These notes can be bought, sold, assigned, distributed. So the note becomes then the asset of the estate. So if you have 3 heirs, you would distribute the note to the 3 heirs, with each getting a 1/3 interest in the promissory note, right?
Sure. Right. Assign that to the 3.
Yeah. So you could still wrap up and close the estate, even with doing a seller carry, if that made the most sense. But one of the things, and I want to get your thoughts on how that might be, worked out. One of the things, and we've talked about this in other shows and on the Creative Finance Collective. And in fact, it just kind of occurred to me now. I'm like, whoa, wait a minute. So let's say hypothetically you have a property, the deceased is still the borrower, but they were fortunate enough to have one of those 3% loans, right? So let's say that you had a property worth $500,000, and it has a, let's just say $350,000 loan against it in the name of the deceased, right?
Mm-hmm.
Well, I, as the personal representative or as the heirs, frankly, could care less whether or not that loan survives or fails, because it's not my credit on the hook, right?
Right.
Yeah.
All I care about is the $150,000 in equity.
Right.
Okay. And we've said this before on shows. In that case, though, doesn't the estate have two assets? They have the real estate and they have the loan at 3%. So if the property is worth $500,000, couldn't the estate potentially sell it for $550,000, cash out the equity, and then just let whoever is buying it take over the loan and just make those payments?
Yeah. Yeah. I think that's a good way to look at it, as two assets that you have there. Yeah. There's definitely a benefit.
I mean,
yeah, go ahead.
yeah, the only to me, as I'm thinking about this, Sean, the only risk that the estate faces is, like you said, is to the extent that the seller carry note includes some of the equity that's not part of the loan you're taking subject to. But one of the biggest hurdles in a subject to transaction is typically the credit risk.
Mm-hmm.
What happens if this buyer doesn't pay my loan? You don't care if you're the beneficiaries of the deceased estate. It's the
Right.
deceased credit that's going
Right.
to take a hit. You don't even care if you lose the property in foreclosure, so long as you cashed out that equity.
Yeah.
So yeah, I mean, I could see a circumstance, Sean, where you don't. It might make more sense because you've got the ability to sell to an investor. Hey, I've got this 3% mortgage, who may be willing to pay a premium for that.
Mm-hmm.
I could see a scenario where the estate may come out better in that
Right.
case. That's very interesting. Let's talk about unreleased liens. Common title issue, whether we're in probate or anywhere else, but we've opened escrow on the property and the title report discovers unreleased liens. Is that something that can be resolved in the probate courts, and what does that process look like?
Sure. That's, again, all of these things get filed as a petition. So we file a petition with the court, then assuming somebody's already been appointed, we file a petition to quiet title, just like we would a civil complaint, and we can handle that there. And so then, again, it follows the rules of civil procedure as far as how the pleadings go, and ultimately it will end with, hopefully, an order from the judge saying that title's been quieted.
What about judgments? I know that there's a whole process, and maybe this is the time to talk about it in probate, to deal with creditors,
Mm-hmm.
but some creditors may have reduced their judgment to a lien against the real property that's existing. How is judgments against the property handled?
Yeah. So when we're doing a probate, you get to this point once somebody's been appointed where we have to give notice to creditors. And so the way that the statute reads is you have to mail a notice to all creditors that are known, and then you publish, again, going to the publication thing, we have to publish a notice to creditors that are unknown. So anybody that's out there that we just don't know about, again, I don't know who's reading those newspapers and looking and saying, oh, hey, there's a notice that this person died. They owe me money. I'm going to go make my claim. But I think the legislature feels better about wiping these out. Because when you publish that notice to creditors, it starts a 4-month clock for any creditor, whether you mailed it to them or you've wiped them out by publication. They have 4 months to come and make their claim. And if they fail to present their claim to the estate, then they're barred from ever collecting against that, unless they're a secured creditor. It'd be great if you could wipe out a mortgage that way, but you can't. And so secured creditors kind of get that special treatment. So at the end of that 4 months, the personal representative's job is to look at the creditors that are secured and any creditors that made their claims. And then there's an order of who gets paid. And the very first thing that gets paid are going to be administrative expenses for dealing with the probate. So that means the attorney's fees, the personal representative's time. The next thing is then funeral arrangements and costs of burial, and then those secured creditors. And so assuming there's enough money to go around, those secured creditors at that point, including judgments that have attached to the property, as a lien, they're going to be resolved at that point. Then we go to any unsecured creditors and all that. If the personal representative themselves is going to sell the property and not wait for the creditor time to pass, then those secured liens are just going to be paid from the closing.
Now, secured liens, just because somebody has died does not mean certain exemptions might still apply. The homestead exemption, for instance, or does that still applies to
Yeah.
the deceased, even if
It
they've,
does.
okay.
Yep.
So they don't lose that just because they've died. So that would be
Correct.
one situation where if the homestead exemption applies, they may be able to move the property without resolving
Yeah.
the creditor
Yeah.
claims in those. What about AHCCS liens or TEFRA liens?
Those are the fun ones.
Well, why don't you explain what those are and how those might pop up, and
Yeah.
then talk about how you deal with those.
So when somebody goes on state aid and they're on access, they're getting funding from the state to care for their long-term needs, their long-term care. Then what a lot of people don't know is that in order to get that benefit, you have to pay it back. It's the estate recovery program that's kind of the second part of getting that benefit, is you got to give it back. And so when that person passes away, the state gets a lien on the property for any amount that they've paid out. And so that lien gets recorded, and you got to wait. And when the person passes away and now it's time to maybe sell the property, you got to get a payoff of that lien and figure out how much was paid out. And then they're going to recover that first as a secured creditor. And so I think a lot of times maybe the children of the person who passed away are surprised by that. They don't know that there's now a lien on the property for that money that their parents received from the state. They've got to pay that back.
And it's usually a lot of money, right? The care
Yeah.
for a person, especially if it goes on for a number of years, unless you've been through it, you don't really appreciate it, but it can get very expensive very fast.
Right. Thousands a month. Yeah.
Yeah. So, how this plays out is, maybe a party has dementia or they need extra help. They just can't take care of themselves anymore at home. The family doesn't have the ability to do it. And receiving state aid sounds like a great thing, because otherwise the medical costs can just basically liquidate your own estate while you're living kind of thing. And they take advantage of that and find out they've got a lien to the tune of $100,000+.
Right.
How are those resolved?
Same as any other lien. If you're selling the property, then you got to get a payoff of that TEFRA lien, and they're going to be paid from the title company as any other lien. If you're not going to sell the property, that's where we've had some success in dealing with those. Because there's a lien, but you can kind of use that leverage of, we're not selling the property. So there's no telling when you're going to be able to get your recovery of that lien. And so we can kind of negotiate that and say, we'll give you this much now and release the lien so that you can get paid something now and not wait another 30 years for, the kids to sell it or whatnot. And you get that kind of negotiated and can get that lien released that way too.
How about the IRS or state tax liens? Are those any different?
You're always going to get those paid. That's one of the ones, nothing's certain but death and taxes. And even after you've died, you're still going to be taxed. Those tax liens are not going anywhere.
So talk to us about, we've talked about some of the common liens that we face. For an investor who's wanting to run in and try to lock up deals and take advantage of real estate that is owned by a deceased person, realistically, what kind of time should they consider this is going to take? I guess step one, from the point in which you can actually get somebody with authority to sell it, and two, to the point of, ending the probate to the extent that needs to be waited on.
Sure. So if the buyer is wanting to just get in and get the transaction done, then, and there's no, complicating factors like siblings fighting or whatnot, as soon as that personal representative is appointed by the court, they can close. They get the certified letters of appointment, deliver them the title, and within a day, they can now close. And so it can happen quickly. But based on some of these other factors, if we've got to go quiet the title first, or if we've got to get lien payoffs and all that, you're going to have to add time accordingly. But as far as waiting for the time to sell, it can be within days. And then if you're wanting to wait, if the heirs maybe are wanting to distribute the property to themselves first, well, then we've got to wait those 4 months for the creditors to make their claims, and we've got to wait that whole process. So start to finish, an uncontested probate, you're usually looking about 6 to 8 months before it's done. But at any point in there, once that personal representative is appointed, they can sell the property.
Given what you discussed earlier about investors' mistakes in trying to lock up properties, and given the time frame kind of we just discussed and what you need to do to get a PR appointed, what is the best way from your perspective? What would be the best and fastest way for an investor to really go try to lock up one of these properties without stepping on a crack and messing things up?
Right. So again, it comes down to the authority question, right? We talked about that earlier, where you have an investor who finds that Aunt Jenny, I think is what you named her. They find Aunt Jenny, right? And she doesn't have authority right now. And so oftentimes the reason that a probate hasn't happened yet is because Aunt Jenny doesn't have the money to go do a probate. And so you get these investors who come in and say, we'll pay for the probate, but then you've got to sell it to us. And so they have Aunt Jenny sign all these documents agreeing to sell the property when she doesn't actually have authority to do that. And so the way that we've kind of maneuvered that in the past is, first of all, if Aunt Jenny then goes and gets appointed as the personal representative, and then she continues along with that agreement, then her conduct is now ratified. So that contract that she didn't have the authority to sign, but now does, now that she has the authority, she can ratify that and say, yes, now that I have that authority, I'm agreeing to be bound to that agreement that was previously unenforceable. So that's one component. But then the other kind of workaround is dealing with the person who is going to be receiving the property, the heir. You don't have them sign a contract to sell the property to you because they don't have the authority. So instead, they can assign their interest to you as the investor. And so that now gives you a piece in that game. So if they're the sole heir, right? And you go to them and say, I know you don't have the authority to sell it to me, but assign your interest in the property to me. Then I'll go and I'll pay to get you appointed as the personal representative. You can then now sell it to me, or just transfer the property to me, because you've assigned everything that you're going to be receiving from this estate. You've assigned it to me. And so it gives that investor the skin in the game with something that's actually enforceable. They have that agreement for the assignment. That is enforceable. And now they're guaranteed to get something. The other scenario is maybe there's multiple heirs. Well, if you can get that one heir to agree to assign maybe their 1/3 interest to you at X price that you would have gotten the deal at, you pay them that amount now, and they in turn assign their interest to you. And now, even if you don't actually end up being the one to buy the property, you're going to benefit, because if they sell the property to somebody else for more, you now get to pocket that proportionate share of the difference, if that makes sense.
Mhm.
So it gives the investor something that's actually enforceable, and it gives them kind of an in to the estate, because now they're standing in the shoes of that heir. So whatever that heir would have received, they now get to receive it. And so maybe it's not the full benefit that they could have realized from maybe a wholesale deal, but they're going to get something. They're going to get the share of the profit.
What about the circumstance where, and I think this happens a lot, and we can talk about trust a little bit, but if you've done the planning side of things correctly and set up a trust, you shouldn't have this issue, this probate issue. But what oftentimes a lot of people do is they set up their trust, then they forget to transfer their real estate in the name of the trust, which of course means that you've got a trust, but you're going to have to probate the real estate. But what they've also likely done, if they used an attorney like you or some other estate planning attorney, is they would have done a pour-over will, which would have named the trust as the beneficiary.
Mhm.
I'm curious, at the point of death, the beneficiary of the state's the trust at that point.
Right.
They haven't received title to it, so that's probably a future interest, but it's vested, meaning the person who had controls died, and that conveyance is going to happen.
Right.
We know that's going to happen. Could you deal as an investor directly with the trust who's going to be receiving it? Could they contract, I guess what I'm saying, their future interest? I'm not really sure. I'm thinking about this kind of on the fly, but I'm just wondering if an investor could look to, in that case, don't know how they would know it without digging through and finding, but I have to imagine that's somewhat of a common scenario where there's a pour-over will at play that
Sure.
makes the trust the end beneficiary.
Sure. And I think that's the case where, again, it wouldn't be a contract for purchasing the property with the
Right.
trustee. It would be the assignment, because there's no disputing that the trust is the beneficiary of that will. It's the only person named in it, or the only entity named in the pour-over will is the trust. So if the trustee then assigns the interest of the trust to that investor, then they'll be the ones to receive that property from the pour-over will once it's probated.
All right. I understand. I think we have one question. Mayu, what's our question for today?
Thank you, Andy. So we do have one question. Thank you guys for putting your questions in the chat. I believe this one is actually for Sean, drawing back to your what if scenario. So the question is posed, if you can remember back to it, the situation with the land contract. Could you offer the court trustee less to sign off?
That's a good question. So less probably doesn't get it done, but maybe more does. So, ultimately, and the question brings up a good point, which is a bankruptcy trustee is their whole job is to find assets. That's how they get paid. That's how they pay their attorneys. And so, the trustee and their attorneys are looking for opportunities to grab assets that would belong, non-exempt assets, right? So homestead exemptions and personal property exemptions, all of those, come into play, but they're looking to grab non-exempt assets and take them as an asset of the bankruptcy estate, liquidate them, pay their attorneys, pay themselves, to compensate them for their efforts in serving as trustee. So the question is, from a trustee perspective, is what's better, keeping the agreement in place or unwinding the agreement and taking the actual property back and selling it? It just depends, right? Depends where you're at in the transaction, depends on, the purchase price under the agreement for sale. But there's always negotiation, or the potential for negotiation. So if a trustee, they know a lot of times, hey, this purchaser under the agreement for sale doesn't want me to unwind this thing. They want the real estate. So, the trustee or their attorney will go to the purchaser and say, hey, look, we're thinking about unwinding this. Here's the purchase price. Here's why we think it's low. We think the fair market value is closer to this. And if we unwind it, here's what we would end up pocketing. Can we work something out? And maybe you as the purchaser say, well, yeah, I can, offer to increase the purchase price or amend the agreement for sale to, up it a little bit. Maybe you don't have to up it to full fair market value, but some form of compromise, because then, the trustee is going to have costs, expenses, attorney's fees, other things like that are going to come out of the total, amount. But if they can agree with you as the purchaser that you're going to come into the bankruptcy court and basically, buy out the trustee's interest or increase the purchase price and make it financially attainable for the trustee to say, okay, yeah, we'll just keep this in place. That could be a possibility. Now, I'm not a bankruptcy practitioner, so I don't know if those, the ins and outs of the negotiations and whether or not they would have to then give, like Dustin said, in the probate proceeding, give notice and give other, investors and people the opportunity to come in and match it. I don't know that. But I do know that there's probably some potential for negotiation with the trustee to settle the matter and, bring a little bit more to the table in order to keep the asset.
All right. Thank you for that. And thank you for the question. Dustin, thanks so much for being with us. We appreciate your time.
Of course.
Tell our listeners how they can connect with you and find you.
Sure. Again, anywhere here at the firm, you can call the main number, 480-788-9911. And then just ask for me and I'll be happy to help out with any probate questions or problems you have.
And if you want to meet with Dustin, they can find you on our website, right?
Yep.
FowlerSt.Clair.com. You can go right on there and click to set up a meeting and do it. Well, we appreciate your time, Dustin. Thanks so much. Good information. Look forward to doing it again.
Of course. Thanks.
All right. With that, everybody, that is our episode. Make sure to join us next week. Also, make sure to join us tomorrow at 5 o'clock for the Creative Finance Collective. We'll see you guys next week.
Have a good day, everyone.